we are on. We are on Exhibit A, and let's just continue with this awesome conversation. You're telling me that they're changing the alphabet song in grade school, and I'm about to cry. I mean, can't they just leave something alone?
I know. It was so unnecessary. It's like one fight we shouldn't be having, but I would be so angry if my kid came home not singing the alphabet song properly.
Well, and there are a lot of ways the school systems need to be improved. I think we could be focusing on that maybe instead of rewriting very fine songs.
Is it politically motivated by chance?
I don't know, but I would be like writing letters to the PTA if I was the parent. Like,
Yeah.
stop this mess.
I want to be able to sing with my grandkids someday,
Right.
you know. And then you're telling me there's new math again. So that's interesting because when I was a kid, I'd ask my father for help with math, and he'd sit down and goes, I can't understand this new math. I mean, there's new math. Is like every generation has new math.
New way of doing it. I know. Well, even in accounting, my dad's an accountant, and I would go to him when I would take those classes in college and ask for his help. And he's either way too smart for me, which is probably the case, or they're doing it a different way. But I would leave every meeting with him a little bit more confused. And I think it's better maybe parents just leave that to the teachers.
I thought, yeah, no kidding. I thought that it's like teaching them a different language almost. Like I thought that your generation was all about new math using the calculator. I mean, you guys, whenever I get on the board and I start writing, you know, my math, you guys giggle. You're like, oh my God, he's doing this. You know, so I mean, it was almost everybody in this office except for me does it the old-fashioned way.
Well, I tried to do, you know, it
Long
by
division?
hand, not long division. No, let's not get crazy. But I try to do simple addition and subtraction with big numbers by hand because I feel like I am losing my ability to do it quickly in my head because I have the calculator all the time.
Yeah.
So I'm actually making an effort, but it can get a little embarrassing if there's a client here and you're, you know,
So
carrying the one.
I grew up with my mom who learned math in like the Soviet Union times, and she had like the most complicated, convoluted way of like teaching you addition and subtraction like fast. She was like, if you see a 7, you minus 3. So if you have like a 7 plus 2, you minus 3, you add a 1, and that's your number. And I was like, I have to do an equation to then do the addition.
I think that's how the new math is. You're supposed to be looking at the numbers and kind of creating like bundles of 10 or kind of bundling them and then figuring out how to do it, I think is how it's working.
Using logic, obviously, of some sort. So next week is Thanksgiving. COVID-19 is, you know, rearing its ugly head again. Okay. The government's telling us that you can't have large parties.
Yeah.
So it begs the question, what are you ladies doing for Thanksgiving and your families?
It's going to be my mom and my dad and me, and actually my boyfriend's roommate because he has nowhere to go. So we're within the household.
Four or five?
It's 4 people and 2 households, basically. So we're within the rules. I don't know who's cooking because we were planning on going out, and now that isn't happening because we don't really cook. So I'm going to have to throw something together. It'll be a hodgepodge, but, you know.
Maybe you could have something delivered. I was thinking the same thing is that, you know, I'm never around my family around Thanksgiving, so I'd have to get on a plane and fly back to Chicago. And, you know, who wants to do that? Because it's usually the busiest time of the year flying. So Maria and I go to a restaurant, you know, or we might have somebody over. And it doesn't, I still love Thanksgiving. I mean, you know, I just absolutely love it. But, you know, for the families out here, you know, like, you know, it's really something. Now, you guys, did you ever make Thanksgiving a really big celebration?
No, not really. Recently, my parents kind of started, but like most of our family is not here in the States, so it was always the 4 of us anyway, and then we would not eat turkey. We would do like fried chicken or like, you know, Armenian barbecue.
Yeah, I'll take the barbecue.
Yeah, I would too.
Yeah, so recently though, they kind of were like, all right, let's figure out how to do the turkey. So usually I'll make everything else and my mom will do the turkey. So that's kind of the thing. But my brother and I sat down and we split up the holidays amongst ourselves. And I said, because I'm the oldest by 9 years, I get seniority. So I get Christmas Eve and I get Christmas. And you get Thanksgiving. And there's, you know, currently a fight as to why it has to be that way. And my only legal authority is that because I said so because I'm older than you.
Oh, my goodness.
And I had to raise you to some extent.
No, my brother usually comes home for Thanksgiving, but with his new job, everyone has to work at least one major holiday, and he kind of randomly picked Thanksgiving, which turns out to have been a good choice because
Yeah.
nothing is really happening this year. So maybe by Christmas it'll be a little better and it will be worth him coming home. But
Yeah.
who
Well,
knows?
he lives in Minnesota, right?
Yeah.
Anything to escape that god awful cold.
He likes it. I don't
Well,
understand.
some people are crazy. Okay.
Well, he has this big
Don't-
beard, so I think that
Okay,
that
all right.
helps.
Okay. Okay. So now we get to talk about the legal stuff. Okay. We wanted to do a public service here. Okay, and that service is letting people know when you can and cannot record folks who you think are committing domestic violence. Okay, so the backdrop on this is that for the longest time, it's always been illegal to secretly record somebody within your household, even when you think that that person is advancing towards you or doing something like that. But there have been some changes. The code has been changed, but we found that the nuances are really important to know. So, folks, first of all, Monet, can you just start recording people when you think that they're going to have a temper tantrum or something like that?
No.
Okay. So why don't you go through, because we have really two scenarios here. We've got one where it applies to spouse versus spouse, right? And then one where maybe parent and child.
Yes.
Okay. So why don't you tell us, because you're going to do the spouse versus spouse or...
No.
I think I'm spouse versus
Oh,
spouse.
okay. Okay, go ahead.
Okay, so I can give a little background too. So it's Penal Code Section 632 that basically lays out the California rules for recording, which requires both parties to know that the recording is happening. The new exception that Dawn was talking about is Penal Code Section 633.5. And it says that the section prohibiting recording does not prohibit one party from recording the communication for the purpose of obtaining evidence reasonably believed to relate to the commission by another party to the communication of the crime. And then it lists a bunch of crimes, including any felony involving violence against the person, including domestic violence. So that's where this exception is coming from. The interesting thing, I think, is that whereas you can get a domestic violence restraining order for a couple of different situations, this exception to the recording law is much more narrow, and it has to be domestic violence as defined in another section, which says abuse means intentionally or recklessly causing or attempting to cause bodily injury or placing another person in reasonable apprehension of imminent serious bodily injury to himself or herself. And then domestic violence is that abuse towards an adult or a minor who is a spouse, a child living in the home, cohabitating. Am I forgetting any of the other?
It's a close relationship.
Close
It's usually
relationship.
blood related or romantically involved or
Right.
something. So what you're telling us is that there is a code now that's on the books that under some circumstances allow you to record when you believe that you are about to become a victim of domestic violence or in the process of being abused physically.
Yes.
But it doesn't cover everything under the family code, because in the family code you were saying that there's other things. So what wouldn't it cover?
So there's cases where there's been a domestic violence restraining order issued when the party has been impersonating the other party, and that was found to be domestic violence because it was disturbing the peace of another person. That wouldn't be grounds to record someone without their permission or consent in this situation. That would still be an illegal recording because it doesn't fall into that narrow definition of domestic violence that the exception uses.
What about the situation where somebody is being verbally abusive, demeaning, just completely controlling the other person, and you shut up, you're not going anywhere, and things like that?
Unfortunately, that wouldn't fall within it either, because unless they were yelling, I'm going to hit you, and that made you reasonably fearful that they were going to do that, you could record then, even if they didn't end up hitting you, because the argument would be it's abuse because they put you in reasonable apprehension of imminent serious bodily injury. But unfortunately, verbal abuse wouldn't allow you to, or wouldn't make the recording legal if you didn't have the other party's consent.
Okay. So you said something about reasonableness. So it's a reasonable standard. Can you explain what that means versus a subjective standard?
Yes. The reasonable person, I'm going back to law school with this one. I wish I had brushed up on that. But basically, what a reasonable person would feel in that situation, it's not enough to say, Don is across the table from me and I feel like he is going to cause me serious bodily injury. A reasonable person, sitting here wouldn't think that.
Depends on
Depends
who's
on
sitting across the table from me.
That is true. That is true. But my subjective belief that he's going to do this wouldn't be enough to meet that reasonable person standard.
Okay, and who makes that decision?
Well, I wish there were a bright line rule for that, but it's going to be the judge. It's going to be very fact determinate, and those are sometimes the hardest cases to litigate because I can feel very strongly that a reasonable person would think this is very scary, and the judge could very much disagree.
Okay, somebody throws something across the room like a cake, something that, especially if you cook the cake, I mean, that could upset you.
Yes.
Would that type of behavior be enough to be able to record?
I would argue if you could look at past behavior, and say, when she throws the cake, then she'll come at me, or when he throws the pie at you, that's the beginning of.
There's a pattern.
There's a pattern here. On its own, it might not be enough. And there are a lot of, it's going to really depend on the judge, I would think.
Okay, so it's kind of hard to advise people when to record that because it seems that there's consequences if you're recording when you're not supposed to be, right?
Technically, yes.
You go, what? Technically, legally speaking, there are consequences. What are they?
I mean, it is a penal code, so it would be criminal. I would still advise if you feel like you are, in fear of someone physically hurting you, I would record and then, let your lawyer look at that recording and see and the patterns and see, if there's a case there. Because you can't go back and record something. You cannot, give it to the court. You can erase it. You can do, you can get rid of it, but you can't go back to that moment and record.
Yeah, it just seems kind of like a statute that doesn't have a lot of teeth because, things happen in progression, right? An argument starts. Husband comes home late. Wife says, "Where were you? I smell alcohol on your breath." And he says, "Shut up," and he throws his lunch pail across the room, right? At that point, probably can't start recording. Unless he's done it before. Let's assume it's the first time, okay? And the lunch pail opens up, and his old smelly sandwich splashes against the wall. That's upsetting, okay? Especially since you just cleaned the house, okay?
Did the lunch pail go towards?
No, it just hits the wall, okay? Then he turns towards her, and he starts walking towards her, and he's got this mean look on his face.
I think a reasonable person would be in fear, and I think you could make that argument that things are escalating and the person is coming towards you. They've already destroyed property, is the argument I'd make, and they're drunk and they have a temper, and it's reasonable to think that this is escalating and it's going to now be physical towards me as he is coming towards me.
Okay, all right. There's no real clear answer though, right? Because it's up to the judge.
It's up to the judge.
Okay. So now we're going to turn to Monet. Monet, you've got a different spin on this because it involves different types of players, right? We're talking about parent-child.
Yeah.
So tell us what the nuance is there.
So trigger warning, child abuse. I'll try to make it as, light as possible because the facts of this case are really sad. This came from juvenile court. So that's another thing to consider. It's not straight from family court or dependency court or even criminal court. This is juvenile court in California making this order. In this case, there was a minor child, about 14 years old, and there was a younger child, and they were cousins. And so the mom had asked the 14-year-old to babysit, the younger one. And that happened. And then the younger kid comes to mom and says, "Mom, I don't want to be left alone with him again. I don't feel safe." So mom is like, that's a little weird. Why? Kid doesn't give any really big details, but he's visibly upset. He's like, "I don't want to be around this kid." So what mom does is before she goes to work, she says, "Okay, I'm going to have him over, babysit you one more time." she puts the camera in the home in a discreet place, and the camera records, her phone camera records the entire duration of this babysitting, picks up a lot of child abuse, you know. And so she goes to the authorities, they arrest this 14-year-old, they try him. On appeal, he says, well, wait a minute, Penal Code 632. And so in really the nuances of 632 is that you cannot record confidential communications that are within the reasonable expectation of privacy, and that comes from the CATS orders. So it's a federal, Scottish Supreme Court decision, CATS, which was very famous. It changed the course of a lot of criminal things. So he says, reasonable expectation of privacy, we're in the home. Why would I expect anybody to eavesdrop? I had no idea that this phone was there. There's no consent. This should have, it's basically fruits of like the poisonous tree. They got this evidence because they did something that they shouldn't have done. They violated my rights, so they should throw this out. And obviously, if they throw the evidence out, then there's really nothing to prosecute him with. This was a matter of first impression, so this hadn't been in front of the court before, because here you don't have a spouse or somebody in a romantic relationship together. You have a child, and the consent to record is theoretically coming from the parent, right? The parent is like, wait a minute, my kid might be harmed. What is really going on? I want to get to the bottom of this. So she's the one putting the video, but she's not being abused. It's the kid. So the court is like, well, what do we do? Because this changes kind of the dynamic of the purpose of 632 and the exception to 632. So what they did was they looked at federal law, they looked at other states, which is often what courts do when they can't find their own authority. And they found statutes that were similar to 632 and our exception. And they said, look, we've looked at all of these cases from like Utah, from New York, from federal court, from state court. And in all of these situations, the parents were allowed to give vicarious consent to the child, the minor child, to record if the parent reasonably believed that that child was being abused, because the purpose of the exception to 632 cannot be possibly legislatively be interpreted to then put the parent in jail for simply protecting their child. The parent's best interest is their child. And in accordance with that best interest, if they need to record to get to the bottom of what's happening to their child, then yes, in that certain situation, the parent can record that incident or what they believe is happening, and that will not be a violation of 632.
Okay. Well, first of all, what case is this?
This is In re Trevor P. It's from 2017, came from the 5th District Court of Appeals, I believe, in Fresno, actually. And so very sad case, but very interesting in how the court is now looking at these other cases. And there was a case from New York that they cite to where the dad had called his ex-wife, and somehow she picked up, but it wasn't like she picked up, like the phone was in her pocket, and he overheard mom and mom's new boyfriend abusing the kid. So he listened, and then he recorded what he had heard, and he took it to the authorities. And of course, same issue, violation of privacy. Of course, yeah, you could say they're in their home, reasonable expectation of privacy, but they said no. As soon as he heard the abuse, he had a reasonable expectation, like any parent would want to figure out what's happening to the safety of their children. We cannot blame parents for this or put them in jail for it.
Let me ask you this. Is in Trevor P., just so we got the facts straight, is it was a mom who secretly recorded the babysitting time where it wasn't his kid that was her kid that was babysitting. It was her child that was being babysat, right?
Yeah.
And what was it, a nephew or something?
It was like a cousin. It was, so I guess her nephew, or it was
nephew,
the kid's cousin. Yeah.
Okay. And the Court of Appeal said that was appropriate. Now, is there anything within the code that the court relied on with regard to the interpretation of this, or was it just based on looking at other cases?
It was based on looking at other cases and kind of looking to see that the legislative intent, when they said you can't record, cannot be used to then be interpreted to be something where the parent would potentially face criminal charges if they do something to protect their kids, because that would mean that the parent just does not have anything to protect their kids.
So in your opinion, based on that decision, does that mean that the recording comes into evidence, or is it just protecting the mom from criminal liability?
No, I think it would come into evidence, and in here it certainly came into evidence. We recently had similar instances
Let me talk to you
But-
about a hypothetical,
Yeah.
okay? Let's assume that you got 3 children,
Mm-hmm.
okay? And their parents are divorced, living maybe a mile and a half from each other. They equal custody, 1 week on, week off, 1 week off. In this particular incident, they're with the father.
Mm-hmm.
Let's assume hypothetically that one of the children's having a hard time because dad wants him to do something he doesn't want to do, clean the bathroom. And the other children are listening to what becomes a heated argument. Okay, they could hear yelling and screaming, right? And then suddenly they hear and then they observe father taking the child by the collar and pulling him across the floor and engaging in what would be maybe excessive corporal punishment. But during that process, one of the siblings starts recording. Okay, now under those that factual analysis, how would the law be applied to it?
You ask a good question because In re Trevor brought that up. They said, we know that this would apply if there's one kid and the parent is recording for that one kid. How would it apply if there's 2 kids and maybe the sibling is doing it for the other kid? We don't know the answer to that.
Was it dictum? Did they?
They didn't say. They said
Okay.
this is without the scope. We all know the courts, if they don't want to rule on something, they conveniently don't, and you're stuck there writing your brief. You're like, please have a decision for me. But no, they didn't, and I think it would be interesting to see what they would rule. I still think that if in that hypothetical, that child that witnesses it texts the other parent and says, this is what's happening, I feel scared. Because we have to also know, in terms of abuse, it doesn't necessarily have to be physical abuse, right? It could be like emotional abuse. But it could also be that you're not physically abused, but you feel the fear of imminent physical harm on you. And you could also have that if, I'm witnessing somebody being abused next to me, that also would apply. So
You would think that it would apply that, I think that dad is about to really hurt my brother.
right. So then you're feeling scared for your life as the
Okay.
kid.
And it's a
you're
reasonable belief.
It's a reasonable belief, and these
Right.
kids, they're not like, usually when we see these cases, these kids are not like 17 or 16 and a half. They're pretty young, and
Mhm.
I think when we're talking about reasonable person, it's really hard when you're dealing with children because, well, what's reasonable to a 6-year-old or a 10-year-old? I don't know, and who knows how the judge is going to rule on that. It's a very nuanced issue. But if in that situation where the kid is witnessing this, they're feeling scared, they're texting their other parent, I feel scared, I think that it's still okay to record, because we have to kind of understand that in this moment, it's such a gray area. If I'm getting a text from my kid saying, I'm scared of so-and-so, as a parent, I'm going to say, you need to record. Now, here's another thing, which you guys kind of touched on, was, well, what can you do, right? So there's present sense impressions. If you can't record, you can write it down. Shortly after, that can come in not as for the truth, meaning not like this actually happened, but to show that you were actually scared. So, you could kind of use this in twofold. You could say, okay, this is the evidence, but also this shows that at this time the kid was really scared, and it was reasonable for them to be really scared. We're not bringing this in for the truth, but we're just bringing it in to say something had happened here, and it was reasonable for the child to be scared. Once we get through that and we prove that the child reasonably was afraid, then we could argue to bring the
Bootstrapped it up.
exactly.
Yeah.
So you're kind of dealing with a lot of evidentiary issues, a lot of nuanced technical issues with these things. But and with abuse, it's something that has to also have happened in the past, right? It's like they always ask like for you to prove past prior abuse. And that's really hard because people sometimes don't record or don't write down, don't take pictures of everything that has happened, especially with victims. That's a hard thing to do sometimes. So sometimes you really only have that one like smoking gun that you're
Yeah.
working with.
Well, you brought up something that needs to be talked about, and that is there's other ways of getting the statements from the abuser and particularly the abuser into evidence. That's present sense impression, or what we call spontaneous statements.
Right.
So maybe we could save that for another day, but that's a really good point. So what I'd like to do is conclude with kind of a devil's advocate thought, Brooke, and that is the proverbial camel's nose under the tent. The situation where we want this stuff to come in and we keep expanding it. But I think a counter argument to continually expanding it is what happens to private conversations. If we say, look, anytime you think that there's going to be emotional abuse or, language that is going to be heated, and it could be abusive in nature, name calling, what happens to privacy within your home?
Well, I think that's a good question, but I don't think we're there yet. The exception is very narrow. I think it was widened a little bit for children. The abuse, it seems like it could be verbal. I mean, in your case, it wasn't, but it seems like they expanded it a little bit there. But with adults, it's a very narrow exception. It's not abuse as you would, use to get a DVRO, which they're, disturbing the peace can be used to get a domestic violence restraining order. For this, they really centered the exceptions to crimes that are violent, or kidnapping, extortion, very violent crimes or very serious crimes. Calling someone a name is not rising to that threshold.
Okay, again, we're talking about the adults, and I should have segued back into that. But we're in the code, when they talk about serious bodily injury, they're talking about the threat of like a broken bone, a smashed face, a broken arm, or something like that. But they don't have to do that in order to record. It's just that they have to reasonably be afraid that it's going to happen, right?
Right.
And, it just seems that it's kind of precarious for us attorneys and to be telling clients, yeah, go ahead and record how do you know? How do you, until you get it in front of a judge and the judge decides, yeah, that was, if the judge says no, then you're looking at the potential of attorney's fees and sanctions and maybe criminal penalties and stuff.
It's hard. And, I wish it were more clear cut and I wish we had more case law on this. But I still feel strongly that it's better to record if you're in fear than to not record. Even because sometimes
you're speaking to the victims out there right now.
To the victims,
not
yes.
to the attorneys, because the attorneys are going to have to be a buffer, I guess, right?
And I think that's, so, the victim records, and it is our job as attorneys to look, is it reasonable to be in fear of serious bodily injury right now? From what I'm hearing, from the patterns, can I make this case to the judge? And of course, you never know what's going to happen when you go in front of the judge, especially with a newer statute that, like I said, doesn't have a lot of case law. There's not a lot of explanation about what they mean. I still, though, as an attorney, would recommend, like I said, someone recording them and letting me decide if we can go forward with our request, or if we, maybe we go forward with the request and we don't include the recording.
Okay, so I'm gonna conclude with one thing, ladies. I am recording you right now.
We're in good behavior.
Okay. So, Mane, how do you feel about this podcast?
I feel like it was great.
Okay, so was that consent? I just picked up my phone and I said, I'm recording you, and you kept talking.
I mean, so, there's a whole issue of like, was it already implied consent because we're in this setting and I didn't stop it?
Okay,
Maybe I'm playing too much of the devil's advocate.
Now you're out lawyering me.
But
Okay.
Never.
No, but my point is this though: is wouldn't you tell that in some circumstances you've got that phone out? You don't have to be secretly. You go, hey, I'm recording you, right? That might alleviate a lot of problems.
Yeah. I think so, and I think another thing to kind of cover your bases is don't just, if you're going to record, don't just record. Write something down somewhere, because if you can't get that recording in, maybe you can get that piece of paper in, or on your phone, the notepad on your phone. It tracks the time, it tracks the date. You can't fake that necessarily. Just write it down. He came, he said this, or she did that, and this is how I felt. Keep a log, because a lot of times the reason why these things we don't have a clear-cut answer is because they don't go on appeal. Either the parties don't have the money, or maybe they're self-represented, or the trial court gave whatever orders. We can't always figure that out, or even rely on a trial court order when we're writing a brief, for the reason that if one of the attorneys might say, look at all of this evidence that I have against your client opposing counsel, and this is what I'm intending on bringing. Here's my deal. Let's just settle it and let's get done with it. And that saves parties a lot of time and money usually, and then we don't get any of the clear-cut answers we need on appeal.
Yeah, I think that you could also use that camera for taking pictures of your injuries and
Yes.
the destruction around there's other ways to use the camera besides secretly recording, right?
Of course.
And I think just quickly to Mani's point, something that we learned in researching is that the emotional state of someone is much more important than I thought. So when you're writing these things down, really, I imagine it would be very difficult to say, how you're feeling, but that's going to go and show, kind of the most important thing. If physical abuse didn't happen,
Yeah.
it's going to show that apprehension, and that's very, very important to this exception.
And if you're dealing with kids, to not get into the hearsay exception, rules, you just say, I looked at my kid. This is how they looked. This is how much they were crying. They couldn't sleep at night. I witnessed it. That's your personal knowledge of impression of your kid. You could bring that into evidence. So really, it's a lot of training and coaching with the client and work, and it's tough. It's not easy to hear those stories, but that's why we do what we do.
Amen, sister. I love it. Well, thank you very much. And come back again sometime
Yeah.
soon.
We will.
Yeah, let us know anytime.
Okay. Thank you.
Thank
All
you.
right, thank you.
Bye-bye.
Bye.